Hello, hello, hello. Uh, Good morning, everyone, or good afternoon, I should say. I have another great topic, so gather around. This is a really important topic, and I really, really, really want to make sure that this information gets around. So I'm on YouTube, I'm on Facebook, I'm on Instagram. Hello, everyone. Join me, say hello when you join in, and let me know where you're joining from. My name is Ifama Odunlami, immigration attorney from the Odunlami Law Firm in Cedar Knolls, New Jersey. We serve clients in all 50 states of the United States because immigration is federal law. So, this issue that I'm bringing before you guys is something that um, has really vexed my soul because I have clients who come to me. Their cases have been denied and they're looking for somebody to represent them. I didn't represent them during the denial, but they have a denial of their VAWA cases, so they're coming to me to see if I can assist them. And sometimes we can assist them, but many times we cannot. And that's what I want to talk about today because they're pitfalls, things that have happened to their case that should not have happened, that has created this situation where they're either appealing the VAWA denial or they have to file a new VAWA case, or that really sometimes there's just nothing that can be done. So this topic is so important that you guys, I really want you to listen in, okay? So for those who do not know me, I think I've introduced myself. My name is Ifama Odunlami, and I'm so happy to talk to you guys today. So please join me, say hello, and let us get started. So I want to talk about VAWA denials. Why are some VAWA cases getting denied? So that is the topic of today. For those who do not know what VAWA is, VAWA stands for Violence Against Women's Act. And this was a law that came into place about 1994. Um, Funnily enough, it was written by this President Biden. And in the context of immigration, it's supposed to protect immigrants who have suffered abuse. And basically, what it's supposed to do is it allows them to petition for their own green card, because there's an awareness that people who are being abused, and especially in marital situations, may be putting themselves in harm's way because they want to get a green card. They may stay in dangerous situations because they want to make sure that they get their green card. So the VAWA encourages people who are in abusive situations, gives them the option, the choice to stay or to go, or and provide services for in certain instances for people who have put in the application. And so, first of all, by way of summary, I just want to talk about what VAWA stands for, who's eligible, and then I'll talk about the issues that I am seeing with VAWA denials. So, VAWA is applicable in 3 or 4 instances. If you're married to a U.S. citizen or a green card holder, and it can be same-sex marriage, it can be heterosexual marriage. If you're involved in a marital situation and you're suffering, you have been abused. Either it could be physical abuse, or it could be emotional abuse, or it could be sexual abuse, or psychological abuse. There are different types of abuse. So don't get stuck on the people out there saying that if you don't have a police report, or you don't have pictures to show you're being abused, that you're not going to win your VAWA case. Most of our cases are based on psychological verbal abuse. We do have physical abuse cases. Those are relatively easier, but there's abuse where you're being emotionally abused. And sometimes emotional abuse can be so cruel, so debilitating, and it can be so harmful. So the law is really clear. It says that you can show physical abuse or extreme cruelty. So there's nothing there that has a requirement for a police report or for proof that you went to the hospital. Nothing there. So I just want to make that clear. So you can find there can be a filing of VAWA in a marital context. If you if you have a U.S. citizen son or daughter over the age of 21 and who has been abusive towards you as a parent, as an undocumented parent, or as a parent who has no legal status or who does not have a green card, you could also file VAWA, right? If you're a child who has been abused by a U.S. citizen or green card holder parent or step parent or adopted parent, I mean, there are criteria for people who qualify as an adopted child. So that has to be met, you know, or step parent. So you could also file. Or if you're a parent whose child has been abused by your spouse, even though you have suffered no abuse yourself, but you've suffered trauma from seeing what your child is going through, you can also file for VAWA. So, these are the denials. I'm going to talk about the main reasons for the denials. The one that I really want to talk about, and I'm going to spend quite a bit of time talking about it, and I really hope to get through to the other ones. The one I'm seeing a lot is a denial of a VAWA case based on the fact that a prior marriage was not properly terminated. Hello, Kamisha. Thank you for joining me. Hello, Lotana. Thank you for joining me. See, it's easier for me to see people on YouTube and Facebook, but Instagram, my screen is so small, so it's so hard to say hello to you all on Instagram, but I'm going to, go through it and try to, give you guys a shout out. Thank you guys for joining me. So let's continue. So the issue is this. If you have a prior marriage, and I'm talking to beneficiaries. I'll come to petitioners later. If you're a beneficiary, that is, you're the person who is trying to get a green card through the VAWA process, and you've been married before. If that marriage is not properly terminated, as in you have a proper divorce decree based on the type of marriage it is, because there are different terminations required based on the type of marriage you have. If you married in a traditional if you married in a traditional marriage ceremony, then depending on what country you're from, USCIS may require may not even require a proof of a divorce, because they may just require proof that maybe dowry was returned, whatever it is. Every country has specifications as to what USCIS is looking for in a divorce decree or birth certificate or death certificate. It's on the internet. So if you are married, previously married, you must prove and show evidence that that marriage was terminated properly. Because if you don't show evidence of that, then your marriage to the U.S. citizen or green card holder who you're filing a VAWA case against is void. Void means that it does not exist, because as far as the law is concerned, you are still married to your first spouse. And because the marriage was not properly terminated, they're not going to recognize your subsequent marriage to a U.S. citizen or green card holder. And what that does is that you cannot get any benefits from filing a VAWA petition. You can not even a marriage petition. This also appears in the context of people who are married to U.S. citizens or green card holders, and they go for, they put in an application, they go for a marriage interview or whatever it is, and there's not a proper divorce. The current marriage will not be recognized, right? And the problem here that I'm seeing is that a lot of people come to the United States and their spouses back home divorce them. And so they take the divorce decree and that's what they use for their filing. And unfortunately for them, that divorce decree is either not properly done, is not properly terminated, or it's just fake. It's a sham, it's a sham divorce decree. It's a fake divorce decree. And the problem is, I think that is that let me talk about Nigeria, because I know this is a problem with my Nigerian cases. In certain states like Lagos, it takes a long time for people to get their divorce decrees, because I guess Lagos is backed up. So they go to people who will promise them to get their divorce decree really quickly, and then they fall afoul of, scammers. And so what happens is, even though the beneficiary, or rather the self-petitioner, this is the VAWA self-petitioner, is not the one who was involved in this uh, fake divorce decree, they suffer the consequences because they have a divorce decree that is not genuine. So what I advise is, if you are in this position where you're here and your spouse from back home filed a divorce proceeding against you, before you remarry, please authenticate that divorce. Make sure it's a proper divorce certificate. Make sure the divorce is real. I have instituted a practice in my firm that if you come from the countries where USCIS questions divorce decrees, you must authenticate that divorce decree or be able to personally vouch for the fact that it is real. And how do you personally vouch? You went to court, you were there in person, and you know that there was a proceeding before a judge. Now, if you are here in the United States and you decide to divorce your ex-spouse, your spouse in your country, do you know that you can actually file a divorce decree from the United States? And I absolutely recommend this strategy because USCIS is not likely to question a divorce decree from the United States. You don't have to be in your country to be able to divorce your spouse who is in your country. And this information would save so much people from, just having their cases denied and not being able to even refile it, or having their cases denied and having to refile, because VAWA, as you know, takes 2.5 to 3 years. Can you imagine going through that process just to start all over again? And I see this so much. I kid you not. I feel like it's an epidemic, really, and I'm not exaggerating. And I ask questions carefully to determine if there's, this person can vouch for their divorce decree. And it's always the same. Well, I left, they divorced me, I got the papers, and now the VAWA case is denied. They say it's not real. Now, let me mention the fact that sometimes USCIS will automatically say that a divorce decree is not real if you come from certain countries. And I don't know why they do this. They just automatically question it. And sometimes we've had to push back because these divorces are real, they're genuine. So we've had to assist our clients in authenticating those divorce decrees. And there are times when we've, as a matter of strategy, we've told the client, it might take less time for you to actually just file this divorce and remarry your spouse if it's not in a VAWA situation. Because in a VAWA situation, that's a little complicated. So that's why it's so important that in a VAWA situation, you must make sure that your divorce decree is real, because you don't always have the availability or the opportunity to file a proper divorce and remarry your spouse, because in the abusive situation, most of my clients they don't have much control over what happens in their lives, right? So now I've talked about a fake divorce in the context of a VAWA self-petitioner, where the VAWA self-petitioner's divorce is fake. That is a reason to deny the VAWA case. In fact, there's nothing any attorney can do. Nothing, absolutely nothing. Nothing. Once I see those denials and the client's like, well, I don't know if it's real, and we find out it's not real, that's it. Nothing can be done. Right? Well, there are a couple of states that there's a different approach, right? But for all intents and purposes, this is a huge, huge, huge problem. So let's talk about when the abuser has a marriage or has a divorce that is fake, or had a marriage that was not properly terminated. In that case, USCIS will actually allow for what we call the bigamy exception. So this bigamy exception only applies if the abuser in a marital situation was married and didn't get a proper divorce, or didn't even divorce and married, the victim. So the victim has to show, number one, to get, this bigamy exception, you have to show, number one, that you had a proper lawful ceremony with the abuser and you had no reason to think that they were not properly divorced. You didn't know that. All right. So that is the issue with regards to divorce decrees. Guys, I wish I could devote the entire conversation to this, because it is just so heartbreaking. I had somebody who came to my office. His VAWA case had been denied, and I was looking at the pictures of the injury his wife, inflicted on him. The woman went to jail. That's how bad it was. They were. I'm telling you, the picture was just so. It was so scary. Like his bone. I think she stabbed him. The bone on his shoulder was visible. It was horrible. And I was thinking to myself, how could this, how could this be denied, So I looked at the denial, and there, of course, it was the fact that his first divorce decree was not properly terminated. And so USCIS did not recognize the marriage, the abusive marriage that he was in. Now, there's another reason that there could have been another reason why he was denied. If the marriage was not bona fide, if he did not prove that the marriage to the US citizen or the green card holder was a real marriage, that he entered into that marriage for the purpose of living with with his abuser as man and wife, or man and man, or wife and wife, but he only entered into the relationship just to get immigration benefits. That's typically another reason why a case could be denied. And typically what the VAWA unit would do is to send an RFE, request for evidence, asking you to provide additional information proving that it's a bona fide marriage. And so if you don't respond to that RFE, or your submission is weak, right, and you cannot explain why that submission is weak, because sometimes we have victims who are not able to show a bona fide marriage because the abuser has cleverly kept them out of the loop on everything, won't put them on the lease, won't open a bank account, won't take pictures, basically just refuse. Then you have to explain that. But if you cannot prove that it's a bona fide relationship, that it's a real marriage, that you entered into it for the purpose of having a life with this person, then you're likely going to be denied. Sometimes I ask clients these questions when they come for consultation. I say to them, what is your proof that this is a real relationship? This is a real marriage. And they tell me, well, I have a wedding certificate. Guys, that is not the proof of a bona fide marriage. And I got this answer so many times that I realized that maybe my question, the way I asked the question, was confusing, because what USCIS is looking for is not the certificate of marriage. They're looking to see that you entered into this marriage to be with this person, and not to gain immigration, not just to get immigration benefits. Now, of course, if you're married to somebody and, you want to be with the person, you love the person, companionship, all that good stuff. And then, you're also grateful that this person is a US citizen and you will be able to get your papers. There's nothing wrong with that. It just can't be the only reason that you're marrying the person. All right. And to determine that, USCIS looks at your intention based on evidence that you submit at the time you got married. So, of course, a lot of times the marriage may not work out. Just because the marriage doesn't work out, you get a divorce does not mean it wasn't a real marriage, or you separate does not mean it wasn't a real marriage. But I want to tell you guys now that if you divorce your US citizen or green card holder spouse, remember that you have 2 years to file your VAWA, otherwise you're time barred. So I think I've talked enough about this divorce decree. Please, guys, really be serious about your divorce decrees. before you get married again, make sure it is your responsibility to make sure that your divorce decree is genuine, because USCIS is not going to listen to, well, that's what my spouse gave me and I didn't know. Nope, doesn't work. Okay? All right. I'm beating a dead horse now, so let me go on with the next one. So the next reason that people are getting denied is the failure to show that they lived with the abuser for some period of time. Now, the law is really generous with regards to this. It doesn't require you to show that you lived with the abuser for any extended period of time. In fact, it doesn't even mention how long you're supposed to have lived with the abuser. So there's nothing, in the rule books that say that you have to live with the abuser for a certain amount of time. And there's nothing in the rule books that say you have to be married to the person during the marriage, because there was a change in the law that says it doesn't matter as long as you've lived with the person at some point, right? You would be able to show the joint residency, right? And you have to have evidence to show joint residency. And such evidence could be that you live together, there's a lease. And in some situations, people don't live, maybe they can't afford to stay in an apartment or rent a place and they're living with a family member. Are you able to get that family member to give an affidavit? Or do you have neighbors who can vouch to the fact that you and your spouse lived next to them, and lived with them for a certain period of time? So the affidavits have to be detailed, and they have to be, they have to give the information that the officer is looking for. So, for instance, if it's for a landlord, I would typically say they want to identify the couple as the people that lived with them from when they lived to when they left, if they have left, how much they were paying in rent, and stuff like that. And sometimes if you have receipts from your landlord, that might be helpful. So we've talked about living together and the evidence that you have to submit to show that you're living together, right? So we've also talked about bona fides of marriage. I think I just talked about that. Those are also reasons if you can prove that it was a lawful marriage and not a sham marriage. That could be another reason why your case could be denied. Now, let's talk about showing abuse. Now, what VAWA requires as the burden of proof for a self-petitioner is any credible evidence. This is as liberal as it gets for people who need to provide evidence. It doesn't tell you you have to get a police report. It doesn't tell you you have to get this. It says any credible evidence. And this is because there's an understanding that people who are in abusive situations may not be able to provide the information. So you have to provide the best evidence that you can. And we've been able to help a lot of our clients think outside the box, because I have so many clients that come into the office, oh, I have no evidence. You think you don't? Let's talk about it. So during the declaration interview, we basically ask a lot of questions and we're able to get more evidence than the client realizes that they have. So like I said before, what the evidence of abuse is physical abuse or extreme cruelty. And the best way to highlight what you've been through is a powerful declaration, right? Your declaration has to talk about what you went through, how it affected you, and and if you have any evidence to support the things you say. For instance, if you say that your spouse kicked you out of the house in the cold, and you slept in the car, or you had to go to a friend's house, well, get an affidavit from that friend who you stayed with. Or I had a client that the spouse tossed all their stuff outside and she called the police, and the police didn't take a report because it wasn't, I don't know why they didn't take a report, because it wasn't, I guess, a violent confrontation, but the police came, observed. And so we're able to get the name of the police, and we're able to we're not asking for a police report, but just, just say what you saw, so it's really important to show that you suffered abuse, because USCIS has this thing that they call marital tension. And I've seen some denials that I'm like, really? That is marital tension? Really? What kind of marriage are you in when you think that this horrible abusive behavior is marital tension? So that's why it's good to just, when you put the package together, you want it to be compelling so that they're not telling you that what you suffered was quote unquote marital tension, And we've talked about different ways that abuse can arise. It typically goes to control. You have a spouse who's refusing to let you out of the house, refusing to let you talk to your family members, refusing to, refusing to provide paperwork when you want to file the petition because they're afraid that when you get your green card, you're going to abandon them, refusing to let you go to school because they think you're going to become better than them and not want to be with them, or putting you in dangerous positions where you could sustain some harm. For instance, your spouse is driving drunk, putting you in fear of your life, or you have a spouse who is insisting on having intimate relations with you in certain ways that you do not want to. They're just different ways. Or in a same-sex marriage case, we have a lot of our clients who are being outed by their spouse just to put them in put them in a position where they face I guess they feel shame because their family members who don't know that they're in a same-sex marriage, or who don't know that they're gay, now begin to look down on them, or to treat them differently. But I just want to say that there are many. Abuse is so you have to explain what happened and what it did to you, because in certain situations there may be something that may not be apparently, it might not look like abuse. And this is also cultural, because I see sometimes I read on Facebook, there's a girl that said she had cut her hair and dyed it, and she came home and her husband kicked her out of the house because she had no right to do anything different to her body without his permission. That's control. And then I saw people there saying, well, why didn't you tell him you were going to do this? And I was just like, what? So you may be talking to a friend and you're saying this to them. This is what happened. Your spouse doesn't let you do this, doesn't let you that, tells you how to dress, makes you take off, makes you, when you're going out, won't let you wear certain things, and basically controls your life. And they're like, well, he's the owner of your head. In Yoruba culture, we call it Oloworimi, and it's okay. Well, in America, that's considered abuse. So you want to be careful who you're sharing an abuse story with, because they may tell you that it's not abusive conduct. That's why it's good to talk to an experienced VAWA attorney. So some of the reasons that people are getting denied is if they don't have good evidence of the abuse, they have a weak declaration. Another reason for people getting denied is when they get married with a pending VAWA petition. Guys, listen to me. If you file a VAWA petition, you cannot get married until that case is approved. If you get married before the case is approved, your case will be denied. It will be deemed abandoned. And another reason for cases being denied is when you cannot prove that you're a person of good moral character. So VAWA has a 3-year look-back period. So you're required to, if you're here, you're required to get either a police clearance or FBI report. And if you spend part of those 3 years abroad, you have to get a police clearance from your country as well. So so that's really it, guys. Let me see if I have any questions, and then I have to sign off because I have okay, I don't know, Instagram is not really moving for me, so maybe there are no questions. I don't know. Let's see. So let me say hello, since I don't see any questions. I guess I answered all the questions in my presentation. So hi, George. How are you? Georgia. Hi, Georgia. How are you? Thank you for subscribing to my YouTube channel. Kasim Jamal says, what about guideline green card lottery? Not sure what the question is. So, and then there's Sama Bruata Esquire, who says, thank you for sharing this insight. You're welcome. And then Taya Abdul says, my wife and her son move out from the house with other properties and also not paying the house rent I give to her. So Taya, if I think you're giving me this information because you're looking to see if it's abusive conduct. For a case like yours, I would need to ask more questions to determine if there's other stuff happening, because typically when certain things happen, I can pretty much tell that there's a lot more going on. And like I said, you want to produce a powerful case for your VAWA to be approved. So you really don't want to just have a case where you're talking about them moving out and that's it. So yeah. Mark Ferguson says, good afternoon to you. Yes, good afternoon. And Stainless says, hey, what did I miss? Stainless, go back and listen to the video. You missed a lot. This is really, really, really good stuff I gave you guys here. So I don't know why I can't get any movement on Instagram. So I can't see any questions on Instagram. So I apologize for that. Guys, I got to run. So I'm just going to answer one more question. Okay. Mami says, can you use a priority date from 2015 on the I-130 to a VAWA application? So Mami, I'm assuming that you were married to a green card holder. And if that is the case, you should be able to use a priority date from that time. But if it's a U.S. citizen, you do not need a priority date because, you're an immediate relative. All right, guys, it was a pleasure talking to you, and I hope you guys got some really good information from this topic. And please, 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 divorces, get properly divorced before you marry somebody, okay? Whether it's somebody filing a petition for you, or whether it's somebody that you want to file a VAWA petition based on the abuse of your person. All right, guys, if you have any more questions, leave it on there. I will come back later, take a look at it, and hopefully it will be the topic of another Facebook Live. All right, take care. Stay well.